Sedeva to take a seat. And now I would request Mr. Kartik Kumar Agarwal to take his seat. So we are starting now the program today. So brief about our program. So this is the Friday lecture series we have started the 8 weeks back. We have already successfully finished the 8th lecture and today is our 9th lecture. Lecture we have decided in the one lecture will be in the criminal side and there will be in the civil side. The nomenclature of the lectures are being taken out from the Delhi High Court websites because the aim is to professional growth of the advocates, those who are practicing here in Delhi. So nomenclatures are here in Delhi. Although we are facing the problem to get our filing done and get our matter listed, so many objections are there. Just to give an edge to our advocates, we have started this program. The another aim of this program is to give the professional growth and improve ourselves, how to file and how to practice and how to argue the matters. So for that, so we have initially formed a coordination committee. All the members of the coordination committee are from the consultation room lawyers. That is why the name of the lecture is Consultancy Room Lecture Series. So it was the brainchild of our senior coordinator, Mr. Prashant Kumar Verma, who has assembled us, Mr. K.K. Singh, Sudhir Kumar, as well as our Nandita Madam, and I myself. He has proposed and we have agreed to start this, and that's we have started. And today is our 9th lecture. So for today's lectures, I would request our senior coordinator, Mr. Prashant Kumar Verma, to preside over the sessions. A few words about the today's lectures. The today's lectures is on the topic of the CS vs IPR. So IPR is a very big field. In IPR, the trademark is coming, copyrights is coming, design is coming, so many things are coming. So we'll be listening from our distinguished speakers about the IPR, how it is being filed and what is the technicalities and what as an IPR lawyer one should take care of proceeding with the IPR matters. Before that, I would request our Madam Nandita to give a few words about our speakers. Although we have only 2 speakers present with us. Yes, madam.
Thank you so much, sir. Thank you so much, sir. Thank you so much, ma'am. Thank you so much. Today's there are 4 speakers. Mr. Chandradal and Mr. Chander and our senior advocate, sir, who is not present here right now, but he is very soon join to us. And Ms. Ashna Sachdeva ma'am, Mr. Kartik Kumar Agrawal sir, and Ms. Hiteshi Kakkar. She is also not here right now, so she will maybe join us thereafter. Mr. Chander and Lal sir is a senior designated advocate practicing law largely in the Delhi High Court and the Supreme Court of India. He founded the law firm Lal and Sethi in 1994, of which he was the managing partner till 2017. He has contributed as a writer to many publications including Trademark Law and the Internet and Trademark Anti-Counterfeiting in the Asia Pacific published by the International Trademark Association. He is considered an authority on intellectual property law and has been lead counsel in many good breaking decisions on this subject. And Ms. Ashna Sachdeva ma'am, she is also about 2 decades practicing in this field and her practice is a very good in this field, and she will give a great enlightenment in this field. Mr. Karthik Kumar Agrawal sir, he is also practicing in this field about more than 1 decade. I suppose it's about 12 years, the practice. Thank you so much sir for correcting me. And Miss Hiteshi Katkar ma'am, she has also a 6 to 7 years practice in this field. Thank you so much ma'am and sir for coming here, and now I'm inviting Shanta Verma sir for the upcoming program. Preside over and the further program.
Very good afternoon to all distinguished members of the bar, the learned friends. One among the senior friend of us, Mr. Mahesh Singh is here, and also Mr. Monty is also practicing, I understand, in this field, is a senior central government counsel. So, apart from that, good people are also here. As all of us knows, it is not only that some 50, 60 people we used to be here in this program. Because of the today's end, you can see a little less participants. But however, I will say that our viewers are not less than 4 to 500. Even the big hall, which is there in the top floor, is a small kind of area for our participants every day, because this program is also available through the live program in YouTube. Now also many people must be watching this. So, without taking much of the time, because our today's program is on civil suit, original side, on which two of the prominent practicing lawyers of our High Court bar are with us. Two are coming. The most important lawyer, we can say that everybody must be waiting. Mr. Chandar Mohan Lalji, he is in this race in court number 45, I understand. But in any case, I had a talk with his clerk also that they are in a process. In case he is through, then he will be any time with us. So, because time is the important aspect for all we lawyers, so we cannot wait longer. So we decided that to start the program. So today's program, as all of us know, that this is civil suit, original side, on IPR matters. Our Delhi High Court handled the majority of the IPR matters in its civil side and in India. So the IPR laws are also quite prominent and quite dynamic also in this field. Mr. Chandan Mohan is no other than amongst those people. We have got good number of IPR lawyers, but we will be waiting for him. But on IPR laws, I will be saying that when we are talking about this civil suit original side IPR matters, IPR constitutes the Trademark Act, copyright, patent, design. Now the recently means the law is there that the GI tag is also there. Another important aspect is on the IC Design Act, Integrated Circuit Design Act, on which recently the central government has also kept a little force on it. That to see to it that as all of us know, the Prime Minister of India says that India is going to be the hub of the IC business across the globe. India is about to invest around 1,30,000 crore in this particular field, IC field. Day before yesterday, our minister in this aspect was also, raising something. They inaugurated a total program on IC also. But at the same time, this law had come, I understand, somewhere around 2000. Even as on date, we have not a single registration in the IC registry of India, which is there in Dwarka, as all of us knows. But time is definitely coming for those people, because the government has also started thinking on those lines that India is going to have the IC designs. The integrated circuit designs will definitely have some litigations, possibly, because those are the areas in which, when we look at, we are going towards the robotics and many other issues also, wherein the role of IC is quite important. But at the same time, the original matters, the intellectual properties like trademark, copyright, designs, all those are also equally important also. So, we will be hearing on this particular issue as to when we are filing a civil suit in Delhi High Court, that is CSOS, in IPR matters. What are the pros and cons and what are the things which are also required to be seen? We will be hearing from our friends, and also we will be also hearing, possibly they will be also prepared with some judgments and the latest ones on which the court must have also put in mind. So, without taking much of our time, so I will request our friend Mr. Kartik Kumar Agrawal. He is a good lawyer also. So, I will be requesting Mr. Kartik Kumar Agrawal to start his lecture on this topic.
Please big clapping.
There's a bit of correction. I am not that much senior, which ma'am told. I am it's been 5 years since my enrollment, and apart from it, I am also a patent agent. So my take would be a little bit of litigation and prosecution. It will be a mix of both sides. So when we talk about original side, there are two aspects of it. First and foremost, why we are seeing an influx over here in Delhi High Court and even Delhi District Courts. Delhi District Courts generally deal with infringement matters and the passing of matters, which we are seeing in the trademarks and even in the patents and copyrights also. It's mostly infringement matters. In Delhi High Court, we have an influx because of the setting up of the IPD benches, which actually came up after the abolishment of the IPAB back in 2021. So, and from that period on, I have seen this IP practice growing at an exponential rate over here in Delhi. Specifically, when we talk about suits, I still remember that back in 2021, when this IPD benches were getting set up, there was a proposal for specialized panels of the experts for these. We all know that we have law researchers and other clerks who are working with the judges. As of now, in the IPD benches, we have specialized panel, technical panels of the experts who are dealing with these IP matters at the back end, who are researching. If you look into the judgments, we have specialized specifically we are talking about the patents. We have specialized research points which are working over it. So, in the original side, when we go, I have seen this is because this is something which I have noticed in the suits. It's a commercial matter, so it's a section 2 of the Commercial Codes Act deal with the IP matters. But what I have seen a lot of lawyers doing is that they have been not researching completely while filing their matters, specifically those who have not dealt with the IP matters beforehand. And my take over this would be from my own experiences, which I have seen, because generally the commercial codes act in a similar manner. We have IPD rules, so we have to set format over it. But what I have seen in these matters is that 2 days back I was dealing with one of the matters wherein what the drafting counsel did was that he forgot to place on record the proofs of the use over here in Delhi. So you fail to establish that cause of action. So these small intricacies are there in the IP matters which actually lead, which may lead to a dismissal or return of the claim. We all know that in trademarks, section 134 specifically deals with that you can sue at a place where the plaintiff resides or operates the business. But then for that also to show, you need to show a cause of action. Then a lot of controversy has been there regarding Section 62 of the Copyrights, again, where the plaintiff, actually jurisdiction where the plaintiff resides or plaintiff operates the business. In patents, yes, we have the jurisdiction where the cause of action actually arises or where the defendant is, that is there with the Section 20 of the Patents Act. But these small intricacies which I have been dealing daily are to be kept on record. Then the second thing which I was I was willing to speak about was that about pre-lit mediation. There has been a lot of controversy around Section 12A. Ma'am might chicken me with that. So people are still very confused about pre-lit mediation. In district courts, we have been dealing that the district judges, commercial courts are not inclined to grant you that exemption from the pre-lit mediation. But in Delhi High Court, we have seen a drastic change, specifically that Yamini Manohar judgment, which specifically dealt with the urgent interim relief, section 39, 1 and 2. But then also it has to go into a lot of scrutiny. There's a matter which I've been giving, it's against, we are for the defendant. Britannia Industries has filed that matter. And because of these all small lacunas in the matter, it has been around 2 years and they've not been able to get an injunction. At the same time, I am myself admitting that they have a very good case. So, because of technical IPR matters are highly technical in nature, they are not of the other, they are not like other matters wherein you say that okay, you can overcome those technicalities. It's a commercial matter. You have strict timelines. Ideally, as per the Act, we have 90 days to dispose of these applications, as per the Commercial Courts Act. It's a high-stake matter, and in order to overcome them, you need to have a proper research. Now, when we talk about the research does not only encompasses the jurisdiction clauses, it also encompasses your valuation, that how you are valuing the cases. Then you have, specifically in the IPD rules, we have that topic called as hot tubbing also, wherein expert evidences are being dealt. So all those rules, all those things have to be taken on record. Apart from it, if you have dealt with the commercial courts matters, the drafting rules and everything is same like the commercial court matter. But yes, you have to take care of the specific formats which have been given in the IPD rules. Apart from it, if ma'am would like to add on to something.
Good that Karthik has given a good start with the entire base of filing of the petitions and what are the jurisdictional aspect is being dealt by the court and the cause of action in normal suits also. Those are the important aspects also in IPR matters. So now we can again shift to the another speaker. She is also having a good practice over Delhi High Court on the particular issues, the IPR matters. So I will request Archana Sahadavaji to give her whatever the experiences in this particular field for last about 2 decades.
Thank you so much, sir. Thank you, everybody, senior colleagues, my colleagues and junior members of the bar, for being here on a Friday. Yeah, for being here on a Friday evening. Thank you. And while none of us are Mr. Lal, we'll try and make this session a little bit more interesting for you. And Karthik has given a very good start. So let me just first clean up the entire space. IPR includes, like Sir rightly pointed out, trademark issues, copyright, designs, geographical indications, IC circuit indications, and confidential information, though it does not fall within the purview of any of the IPR subject matters. All of these have been classified as commercial disputes under the Commercial Courts Act. So while they are all civil disputes, the distinction comes because they are all being classified as commercial dispute under the Commercial Courts Act. So the moment you are wanting to file an IPR suit, while it is a civil suit, you have to pick up the Commercial Codes Act. The general rules of how a CSOS is filed varies, it's starkly different from how a CSOS commercial is filed, be it before the district court or before the high court. The only distinction between district court and high courts is the pecuniary jurisdiction or the specified value of your particular dispute. If the specified value of the dispute is between 3 lakhs up to 2 crores, you can go to any of the district courts in Delhi, basis of course the cause of action, place where the plaintiff resides, or place where the defendant's business premises is, usual sections, section 20, sections 132 and section 62, as rightly pointed out. So jurisdiction is the normal, like how CPC applies as well as trademarks and copyrights apply. So you can decide your jurisdiction, but basis the pecuniary jurisdiction, you either go to the district court. If the pecuniary jurisdiction is 2 CR and above, that is when you come to the high court. Otherwise, there are specified and designated commercial courts in every district court as well as the high court, which only deal with commercial matters. So commercial matters are all the matters which have been specifically identified under the Commercial Codes Act and defined. So IPR is one such category. Point number 1. The legislative intent behind categorizing IPR disputes under the Commercial Codes Act is to ensure that all disputes in which there is issue of some commerce or which actually is helpful to businesses in India should not be held up by long-term litigation. The idea of categorizing it is Commercial Codes Act has been drafted and legislated specifically with the intent to cut short the time span or the lifespan of a litigation. Therefore, the timelines which are specified in Commercial Codes Act are vastly different from CPC. For instance, in a civil suit, if for written statement you have some time which perhaps is condonable by a court. In a commercial dispute, including an IPR dispute, after the period of 120 days, the courts have no discretion to take your written statement on record. There is absolutely no discretion with the court. So the timeline is 30 days plus additional 90 days. But after the cumulative period of 120 days, there is absolutely no discretion vested with the court under the Act to allow your written statement to come on record. Your right stands closed. Similar time period for a replication is 30 days plus 15 days. So cumulative 45 days from the date of receipt of the written statement. If the written statement is taken on record on that day, assuming it's filed in 30 days. So one needs to be very careful when picking up any commercial dispute for that matter, not necessarily an IPR. The moment it falls under the Commercial Codes Act, there are a lot of steps that you need to take care of. Also, the most important one, of course, like my colleague here pointed out, is the pre-litigation mediation, or the step that you have to take into consideration before you go to court. So section 12A of the Commercial Codes mandates, again, with the intention to remove disputes as soon as possible, that before you go to court, first give a notice to the other side, see if a out-of-court mediation is possible. If that is failed, then please go to court and file a commercial court dispute. There is, of course, there are different Supreme Court rulings interpreting this section and whether it is actually mandatory, and if some party does not abide by it and goes directly to court, can the suit be rejected under 711? So the Supreme Courts have interpreted the section to say that as long as you are making out a case of immediate urgency in the suit, your suit can be entertained even if you do not approach or avail section 12A. But then that means while drafting a suit, one needs to be very mindful of this. The suit has to be drafted in a manner that you are showing within your pleadings that there is extreme urgency for you to come to court, and because of which you are not first availing of the section 12A remedy. So that should come out from a reading of the pleadings itself. So that's number 1. So that is one thing. In fact, the latest Supreme Court judgment on this is the Dhanbad field. Right? It was only on 15th of 2025. Yes, 15th May by a bench of Justice.
Last was Justice Naveen Chawla.
No,
Saurabh Banerjee.
Supreme Court decision. The Supreme Court decision is Dhanbad, Pardiwala, Justice
Okay.
Pardiwala.
Right.
Yes. So that has now conclusively interpreted Section 12A. Your suit will not be thrown out because you haven't availed the mandatory Section 12A, as long as you're able to make out in your pleadings that there is an urgent relief that is required. So this is one very important step that everybody needs to be mindful of. So we have taken care of the pecuniary jurisdiction. Now, just to go back to pecuniary jurisdiction, if the valuation of the suit is less than 3 lakhs, even though it's an IPR, it will fall out of the Commercial Codes Act. Because the Commercial Codes Act specifies the specified value. So even if, so assuming the dispute is less than 3 lakhs, it could perhaps fall out of the scope of Commercial Codes Act. It will be normal CSOS. Wherever the district courts it will be filed. It will obviously not come to the High Court. Yes. The moment the dispute valuation is 3 lakhs and above, then it goes to the commercial divisions of either the district court or the High Court. So Section 12 is what one needs to be very mindful of. Then the other things that have been introduced in the Commercial Codes Act to increase accountability by parties is introduction of statement of truth. That is not something that we file along with our civil suits, which are non-commercial. But with the commercial suit, you are required, the lawyers are specifically required to file statements of truth where the authorized representative of the plaintiff deposes on affidavit that whatever has been disclosed is true to his knowledge, and every document in his power and possession, be it against him, is being filed along with the plaint. This assertion is very important because under the Commercial Codes Act, the manner in which subsequently documents can be taken on record at later stage, it's very curtailed. So it is mandatory and crucial that at the time of filing of the suit, each and every document, even if the document is not in your favor and pertains to the other side, is disclosed and brought on record. Because subsequently, if the leave is sought by the court that I want to file additional documents, you have to show the statement in truth whether you sought this leave. Whether did you disclose that I have this document but currently it is not in my possession, I seek leave to file it on thereafter. Whether this document at the time of filing of suit was in your power possession. So there are a lot of issues in bringing on record additional documents subsequently. So there is an introduction of statement of truth. There is an introduction of documents being filed, disclosed at the time of filing your respective pleadings, claim or written statement. Then a certain yes, of course. The formatting obviously has also changed. If you will see the very index in which a list of documents are filed. Now there are a lot of assertions to be made. There are a lot of, even in the index document, it's divided into multiple parts. As in mode of execution of the document, how the document came to be with the specific party. Correct, 7. There are 7 heads. So as opposed to where in the civil suit we simply say serial number, particulars and page numbers. Here, aside from these, there are 7 heads. So you have to describe in whose possession the document was. What was the mode of the document transfer? Correct. How was it executed? Whether you are filing a photocopy or an original. So these are all formats which are inbuilt into the Act, which have to be taken care of, because without these, your suit will not be registered as a commercial suit. All of these will be flagged as defects. Then the other mandatory provision is that your written statement and the replication to the written statement have to be accompanied by affidavits of admission denial. Mandatory. So if the written statement is not filed along with your affidavit of admission denial within that 120 period outer period, then your written statement will not be taken on record, is what the Act specifies. So it is not an option ki admission denial mein baad mein kar dunga. So and similarly with replication. With the replication, the affidavit of admission denial has to be placed on record. So these are certain, all of this you will see there is a very clear intent of the legislature is to cut short the time. Do everything quickly. Do everything quickly together so that before the joint registrars repeated dates are not taken कि हम admission denial का affidavit upload करेंगे, next date पे हम admission denial करेंगे. So all to cut short the entire process, they have made the Act very strict with consequences in case of failure to adhere to those. Then another thing, additional documents.
Not for additional documents. Basically,
Basically, we have order 11 application also around the list of documents. If you are filing for the electronic records, generally what we do is that we used to file 653 certificate. Now it's 63 of the new act. But apart from it in IP, specifically in the commercial matters, we have to file an additional affidavit or you can say an application under order 11 also, wherein that is in support of the electronic evidences. And apart from all these things, my learned friend rightly pointed out that we have a 120 days limitation, but it is actually 30 plus 90 days as per the 8 also of the CPC. It is 30 plus 90 days, and if you are seeking condonation after 30 days, the court has the discretion to impose cost. So, and in commercial matters, the cost can vary from like a few thousands to even lakhs of rupees. That there is no bar over imposition of these costs. So these limitations in the commercial matters are a very strict limitation, and we need to adhere to those points.
Then there are other few provisions in the Commercial Codes Act. So this applies to any IPR dispute because all IPR disputes are categorized as commercial disputes.
Yes.
So any IPR dispute, if you're filing a copyright trademark, I'm not talking about the subject matter of the dispute. It's just that it's a commercial suit. Another good thing in the Commercial Codes Act is the summary judgment. So you can seek either party, be it the plaintiff or the defendant, in a commercial suit, can seek a summary judgment, but this application has to be filed prior to framing of issues. But what they have to make out is either the plaintiff or the defendant do not have a chance of winning this case. So then this application can be filed on the basis of pleadings before issues are framed in the suit, and the suit can be decided summarily. And another thing that happens in IPR or in commercial matters is case management hearings. Case management hearings are when the judge is presiding over your matter and he's fixing strict timelines for your IPR disputes. Filing of evidences, filing of list of witnesses, the time within which the evidence of both parties has to be concluded. So all these timelines are fixed in case management hearings held by the judge. And then of course the matters are sent either to the learned local commissioners who are appointed or before the joint registrars wherever the evidence is happening. Now in a case management hearing, aside from fixing timelines, judges also have the powers to strike out certain issues, add parties. So depending on what has happened till then in the evidence, they can take note of it, and in the case management hearings itself, the judge has certain powers to perhaps let go of certain prayers, say this no longer suffices for whatever reason, strike out any issue. So this also can be addressed at the case management hearings without having to wait till a final adjudication that this was a preliminary issue, please go decide कीजिए or something like that. That happens. Then anything else under the Commercial Codes Act?
Under the Commercial Codes Act, almost everything is covered. One topic which I actually wanted to strike on is that prior to institution of the suit, what I have seen is that people do serve a cease and desist notice also, which in general cases I am really very against of it. And the primary reason is that the IP matters are a very high stake matter. And by serving that cease and desist notice, the possibility generally court grants ex-parte, but the issue with cease and desist notice which I have faced in one of my matters is that the infringer actually got time to dispose of the infringing goods. So our entire case failed because of it. So in civil matters specifically, you don't really need to send any notice prior to it. What you can do is that if you really want to first try to mediate it, you can simply start with section 12A. Go and file an application before DLSA with your entire case, and the section 12A can be complied with. The benefit of it is that first and foremost you are complying with 12A. You are making out that case. आपका वो जो पीरियड है 1 महीने का जो आपका जब नोटिस में 15 दिन का या 1 महीने का जो भी नोटिस देते हैं वो आपका ना देकर आपने वो सारा का सारा अपने 12A में निकाल दिया. and then you can immediately come before the court and file the case. Generally, cease and desist notices are served in cases where you know that there is actually the possibility of a settlement. And apart from it, when we are, like my learned friend also pointed out, that when we are seeking the urgent interim relief, there is a judgment of Bombay High Court. I am extremely sorry that I have forgotten the citation. But there is a judgment wherein this issue was also decided that when you are coming for the urgent interim relief, and although you might have made out a case, but what about the time period which has been elapsed? Generally, what happens is that people say that from we came to know at this point of time, and then they just leap over the case and they don't file any application or any case before the courts. And then they suddenly wake up one day and file a 39 1 and 2 along with it, seeking the urgent interim relief. That is not the case. You have to be very strict with the timelines. You have to make out that urgent, you have to show that urgency that this is the reason that why we were not able to take the action or why we are now approaching the court. Like in today's matter only, the Justice Karia actually pointed it out that you were aware that they were making these trademark applications and then also you slept over and never came. Now we had the case that we already had taken action against them, but now they have came up with another application and now they're about to launch the products in the market. So that's why we have that urgent interim relief. But if you don't have that period, then how will you prove that urgency in the matter?
Yes. And while Sir rightly pointed out that Delhi High Court, of course, has been always known for granting ex-parte orders in IPR. These days, as a matter of practice, what I have noticed is that the learned judge at least asks for an advance service being done on the other side. So, barring those cases where we perhaps are seeking execution of local commissioners and without them knowing, as a practice, what we are doing is we're generally giving an advance service of the suit to the other side. Otherwise, you have to make out an extremely urgent nature of the case while you're arguing on the first day, warranting issue of ex-parte orders. Either it's a John Doe matters, where you do not know who the other side defendant is, Ashok Kumar matters. So either it's that case where it's rank counterfeiting that is happening, or alternatively, it's a case where you know who the defendant is, but you want seizure, execution of local commissioners. Of course, to frustrate the whole process, if you give them advance service, they will take away all the stuff, infringing products. To avoid that, we can ask for an ex-parte. But otherwise, as a matter of practice, the judges, at least in the High Court, I'm not sure of what's happening, maybe it's being mandated in the district courts. But in the High Courts, at least the judges want us to at least serve an advance copy of the suit to the other side, and even on district courts. And on day one, perhaps if they are there, it's easier to hear them and then grant a 39 1 and 2 instead of granting a 39 1 ex parte and then a 39 4 application following.
So, we take both of the big hand, and no doubt we are waiting for Chandar Lalji. I don't know whether he is in a position to come today or not, but rather to continue it for some time. We have also the lawyers, those who practice in consultancy room, as I was saying. Sanjeev Montiji also used to have some filing and all many other things. But apart from that, Sudhirji is also having some experience, direct experiences also in this issue. So Sudhirji, I will be requesting you to be here also to come this side. To also address on this issue. For 5 minutes, you can say that.
Sudhir, please.
So usually I'm always here to deliver the vote of thanks on behalf of my learned organizations. Definitely.
We are not reached to that level. We are only waiting for you to
But
hear.
usually actually IPR or IPR related cases, because I know me and my learned friend Anish Shrestha is here, we had argued very much on Al-Qasas family, Kakori Kebab and various other issues and day back since 2008-2009. So these were the 2 years when we actually argued on even whether the process of making kebab can be patented or can be copyright, or whether the ingredients which is the part of kakori kebab can be registered by process family. But before that, let me tell you one thing very important, because we have an IPD division before Honorable High Court of Delhi. So in year 2022, Delhi High Court under Delhi High Court Act Section 7, apart with or read with Section 159 of CPC, with intellectual property right boards by that time conferring their power, and Tribunal Reform Act of year 2021 made DHIPRD 2022, which actually made this, yes, IPD division, which is functioning before the Honorable Delhi High Court. And believe me that Honorable High Court of Delhi and the Honorable High Court of Chennai are having such important original site jurisdiction. And correct me if I am wrong somewhere, especially Mohanty Sahab, because on these issues we come to know over having Bauddhik Sampada Bhavan or the IPR houses in India, which is very important, because I know patent attorneys are actually made from the Bauddhik Sampada Bhavan. मैं भी पेटेंट अटॉर्नी रहा था कुछ समय तक, लेकिन ठीक है मेरे को उतने ज़्यादा केसेस नहीं मिले थे. But unfortunately or fortunately, because of my learned friend Anish, we used to have the arguments on kebabs issue, जो कि बहुत अच्छी delicacies होती है. But before that, let me have you one, I can give you one insight which we had prepared on the main features of this DPIHRD rules 2022, especially the IPD. When we are speaking about intellectual property rights, then we are speaking on what kind of issues that can be taken care there. Because my learned friend Archana ji and Karthik, they have given such a wonderful discussion, which is not even technical. They have told you the easy thing on how to prepare your file, your gist, your argument, where to file, and what is important. That after or with every written statement, your affidavit for admission denial should be the part. Otherwise, your complete case will become zero. But yes, on speaking to the IPRD, we people can speak much. But on the rule 2.1, now correct me if I'm wrong somewhere, Ashna ji. It emphasizes IPR, intellectual property rights, as a subject matter for the rules which include what? Now these are something very important matters which are coming over here. Matter pertaining to patents, copyright, trademarks, geographical indications, plant varieties, designs, semiconductor integrated circuit boards, layout designs, special layer designs. So because we are having not even the electronic chips, but there are green chips also. And green chips is holding something very different value. ताइवान ही नहीं सिर्फ इंडिया और यूएसए भी इन चीज़ों में बहुत ज़्यादा इन्वेस्ट करता है. And the traditional knowledge and all rights under the common law, which is usually associated with matters pertaining to passing off, acts of unfair competition, disparagement, comparative advertising, etc. Protection of your trade secrets, because when the companies are very much important. What is the company's trade secret is actually my trade secret when I'm representing them. And in order to save those trade secrets, one should know what is the kind of IPD division I am approaching before Honorable High Court. And in that, in my trade secret, what is my pecuniary jurisdiction? Usually everybody will say that my trade secret is up to more than 10 crore, 5 crore, yahi se shuruaat ho jati hai. But what actually is the valuation? As a patent attorney, it is the role of a patent attorney to tell the company or their clients what could be the valuable part of the trade secrets. Trade secrets is a very important thing. One, as an advocate, even if you are not approaching by the companies for their IPR rules, but you should be having this complete knowledge why trade secrets are so much important in the corporate governing world. This corporate governing world is ruled by trade secret, even the business, conduction of a business or conduction of your human resource policies. We have a POSH Act. And POSH Act is just not one secret, it is a rule and a law. So please understand that any trade secret can become your management intellectual right. और management को इतनी बातें समझ में आनी चाहिए कि वो किस चीज को क्या कह रहे हैं. Then apart from that, what we shall take into before the honorable courts? tortious actions. Whether tortious action can be taken, answer is yes. Tortious actions which are related to privacy and publicity rights. Then we have matters which are pertaining to our data's domain, exclusive domains, data protection. We are also waiting when the DPDP Act will be actually coming into force, which is very important how data should be protected. My data, my company's data, even the law firms have their own data because we protect the complete information of our client company or their trades or whatever the product that actually we are getting patented with them. One important thing, ये जितनी बातें मैंने बोली ना उसमें हर एडवोकेट को LLB बैकग्राउंड है लेकिन साथ साथ साइंटिफिक बैकग्राउंड की नॉलेज होना जरूरी है. Understand that, especially when we are dealing with the issues of plant varieties. Then one should know what is the forestry, agronomy and botany. And then when we are dealing with the conductory boards, semiconductor boards, one should know the knowledge of engineering, the skills that actually make the IC board. You don't have to tell what is this IC board. You have to tell how important is that IC board which is being made by our client company, and if somebody is infringing on my design, then I have the right to infringe, to question their infringement and to take the proper compensation or to pertain to sustain them not to use my technology. That means I can also get patented my technology. My technology is my right. I am spending so much of money, investment, my peoples, my persons who are actually dependent on my company. Why shall I get other people to take advantage unless they say that yes, this is the value of your technology, we are using it, and with your, what we say, joint collaborative agreements, shall be taken care by that. And usually those agreements are made by whom? Advocates, not anybody else. Only the advocates know how to make a very good, very smart, effective, and a clever agreement to save rights. Now, apart from this, there are various other issues, various other points which can be taken care of in our data exclusivity, that is our matters involving internet violations relating to any subject matter which is defined under clause 1 and clause 5th of section 2 DPIHR rules, that is known as patent rules now 2020. Rule 2.1. Now this gives a very great and wide explanation what else apart from the issues as a subject that I have told you can be taken care of. And very important thing is Information Technology Act 2000. So can we use something which is called Information Technology apart with our IPRs? Answer is yes. Very greatly in Patent Rules 2022 it has been implemented, and apart from that, if we go through some good judgments, I will definitely give some 3 cases which actually was handled by Honorable Senior Advocate Chandaram Lal Sahab. Because I will tell you what is the subject line of that subject. Apart from that, argument is a different issue. But do understand what is the subject line, because every advocate must know the masthead, that is the first page of their drafting. How it is made. Before the Honorable High Court of Delhi, civil or writ petition civil, in the extraordinary original jurisdiction, but apart from that, then come with the most important part, IPR division of what? What is that you are saying, or what kind of jurisdiction should go over there in the court? Because that is actually define your own particular point pertaining to your own petitions. The important thing for the information technology one should understand is rights and liabilities of intermediaries. The rights, liabilities of intermediaries are those companies who even can involve the digital manufacturers or the digital marketing firms. Because everybody have their own policies, their own strategies, memes. ये जो इतने memes बनते हैं, क्या मैं किसी और का memes अपनी किसी और product का use करता हूँ? Answer is नहीं. Because it is definitely covered under the Information Technology Act, but DPDP Act has not been implemented right now. Otherwise, it will become more important, powerful. Apart from this, our Information Technology Act, then online marketplaces. ऑनलाइन मार्केट प्लेसेस तो आप किसी को भी समझ सकते हैं, हम किसी की भी बात कर सकते हैं, चाहे वो जोमेटो हो या चाहे वो फ्लिपकार्ट. तो फ्लिपकार्ट और other companies who are using the online market traders, devices, the grounds, they are actually using this law very beneficially for them. their company policies, because whenever you go and make any company policies, और मैं चाहूँगा कि आप लोग company policies को भी develop करना शुरू करें, तो companies policies में ये definite है कि उन policies में आप जिस चीज को, जिस right को save कर रहे हैं, वो उस policy में होना चाहिए. If it is not written, then whether you can save your company policies, answer is yes, but then it becomes another issue. Then infringement is not there. Then you have to make your policies to be governed according to the company rules. The company rules, company act, and apart from this IPR, there are interwoven with each other. एक दूसरे के आसपास हैं, दायरे में हैं. अब एक एडवोकेट की समझदारी है, उसका इंटेलिजेंसिया है कि मैं कैसे और किस रूल को कहाँ यूज कर सकता हूँ. That is our arguments. Final argument contains of these things, but before that, what is important apart from Information Technology Act? Within the purview of the subject matter of all this information technology, we must understand how our other petitions part should be taken care of. But before that, there's one subject matter has to be deal with the purview of intellectual property rights, and that is the definition under Rule 2W of Information Technology of 2000. Because it also says very much interlinking point with DPIHRD Rules 2022. That's a wonderful, you can say, interpretations, intermoving interpretations, or the law which has been made in order to protect the subject right. अगर आप अपने सब्जेक्ट राइट को नहीं जानते हैं तो आप आर्ग्यू क्या करेंगे, आप रिप्रेजेंट क्या करेंगे, आप किसको बचाने आए हैं और क्या बचाने आए हैं, क्योंकि फिर एडवोकेट की ड्यूटी 200 टाइम्स मैनीफोल्ड हो जाती है बिफोर कोर्ट, क्योंकि साथ में आपके अपने एसोसिएट्स खड़े हैं, इधर ऑपोजिट पार्टी खड़ी है, पीछे आपका क्लाइंट खड़ा है जो सबसे ज्यादा आपको देखेगा, वो बताएगा कि आपने ठीक बोला या नहीं बोला. Honorable court, because honorable court know what is coming in the company's court. So this is how these things happen. Then we have our Rule 2.1, which actually also define various revocation applications, cancellation applications, original proceedings, appeals, petitions from various IPOs, and proceedings which were hitherto maintainable before IPAP board. अब वैसे आजकल जितनी भी IPAP बोर्ड की पावर है वो सब IPT डिवीजन में आ चुकी है. बट एपिलेट बोर्ड क्या कर सकता था और एपिलेट बोर्ड के पावर क्या हैं? बिफोर मेकिंग दैट योर ओरिजिनल एप्लीकेशन वन शुड नो एपिलेट बोर्ड इज देयर. So these are the various simple things that one must understand before making their original claim. And now, apart from this, I'll give some little bit of some information of there's some important cases which are happened in Honorable Delhi High Court, and Honorable Chandan M. Lal Sah was actually the main advocate for the companies. In year 2025 June, there is a very important judgment which come by Justice Saur Banerjee. It was in the Birkenstock counterfeit sales. Now, Birkenstock is a German company which is specialized in making footwear. And they come to know that in complete Karol Bagh area of Delhi, the Birkenstock footwear design counterfeiting is going on a very high manner for complete India. And Karol Bagh is the hub or the market which is actually providing that same design, though not of the quality, but the same design as in counterfeit to complete India without making any efforts. Now, what are we saving here? What is the subject line that should go? This is where the intellectual and the intelligentsia of Honorable Sri Chandra and Lal Sahab is there, but in very simple line he is different. I'm reading that, which is the brand of footwear. This Birkenstock GmbH plaintiff is an NLP in India. Permanent injunction was asked against defendant to restrain them from what? From its intellectual property, trademarks, copyright and registered design, because that design was already registered before India. And we all know what is the value of our footwear now. How smart somebody can look in their suits or in their saris or whatever the clothes that we wear, but whether that design can be counterfeited, answer is no. That's why there's a restraint has been asked by Honorable Senior Advocate. And definitely that company has asked for it. They have spent so much of time, money, effort. They will definitely come, other people and stop them to do not copy, do Do not copy my design unless you are told to do so. I think this is a very important judgment. You are also the part of.
I wasn't, sir, but it's a very good judgment.
It's a very good judgment. It's a very on judgment, Sir Banerjee, sir. Because okay. Section 2C copyright was there. Though there is another good judgment, Marico Limited versus Dabur India, which is pertaining to advertisement of similar nature. Saurav Chaudhary versus Union of India, given by Justice Pratibhan Singh in very in a detailed manner. Request for examination, and the first examination report was RQ. So it's a very big topic, RF and FER. We'll discuss it later. But now, what is most important is that one should understand even in this brief meeting that when you are going for an IPR, you must go full-fledged. Now I'm handing over the mic to my learned senior, Shri Prashant Verma Sahab, for the further proceedings. And thank you.
We have never expected Sudhir will be also so much so into the entire lecture series. But give him again a big hand, Sudhir. So, because now also Chandralal ji is also continuing with his argument. So instead of waiting, we will be also waiting another day. Possibly in next one or two, after next one or two series, we will be expecting him to be here. Like our friend Mr. Sanjeev ji. Sanjeev ji will be a speaker in a issue. So whatever that as it may be. So today, as we have discussed on the CSOS IPR matters, in CSOS IPR matters, as everybody knows that when we have a matter which is of civil in nature, but now after 2005 we have made it as a commercial division courts of our nation. That is also, that aspect has been argued before the floor of the House, and it was felt that across the nation, all the high courts in India shall have a commercial division. So, based on that, our Delhi High Court has also come along with that commercial division. Prior to that, we were also handling that equal number of matters in IPR in civil side, that was in CSOS only. Now CSU is commercial. Today we have discussed a lot, and which Madam has also shared. What is being left out, I am just trying to conclude hearing, is that Order 7, Rule 11, whether that is seized or not, no, that is there. You see, you can always ask for the rejection of a plaintiff. Whenever there are certain, everybody knows, Order 7, Rule 11, there are certain provisions on which we can go to the court asking for the rejection of the plaintiff. I am not going detailed into that, but that is an important aspect when you are depending in a case of an IPR matter. So is the case of judgmental admission also. So that is also there also. And whatever are the commercial courts provisions are there, that is in addition to the CPC. Similarly, there are important provisions like as you were also mentioning that while filing the index of the documents, that how it has come to you and what are the things. And those are all also equally important. What we lawyers sometimes helps to understand, that is when we are filing a plaint, it has to be along with it the evidences which we are having, which is followed by way of a list of documents. Now, in list of documents, there are certain additional features on which how the document has come or not. So, when we are filing the list of documents, we must file the original documents. As in our commercial division, nowadays in Delhi High Court, we are having the PDF format of documents. So, when we are filing the documents, there are law on that. That is Order 7, Rule 8 and Order 8, Rule 1, which says that in case you have not filed the evidences along with your plaint or the written statement, without the leave of the court, you cannot go on filing the documents. The day when you are filing the plaint, whatever the documents which are supposed to be there to substantiate or prove your plaint, so you have to file it on that day. If you are not, then you will have to, in a later point of time, if you are coming with certain documents, then the leave has to be often Order 7, Rule 14.3. Similarly, when in a defense, in a written statement, whatever the documents which you are relying upon, it has to come along with the written statement. If it is not, then under Order 8 Rule 1A, you have to leave it, you have to obtain the leave of the court. So there are certain areas on which we have. Similarly, another provision is Order 39 Rule 10. In case we find that after some time a person plaintiff or the defendant may not come forward or he may plead, there is all likelihood that after the decree is being obtained, then the decree cannot be given effect to. So in those cases also, we have to call for that person. Then Order 39 Rule 10 is also there. So is the case of 340 provisions is also there now. After BNS also there is an amendment. So a person who is filing the false evidences. So these are all basically the civil procedures which we have adopted and also taken care of in all our civil matters should be available in the commercial division CSOS commercial in along with the commercial code acts rules and the provisions which are there. So with all this, I think I'll conclude myself and today will be, I'll request Mr. KK Singh to give a vote of thanks. Definitely I said that we will be hearing some other day, Mr. Mohanty S. K. Mohanty.
सर इस रूम में वैसे भी आवाज आ रही है
कोई नहीं, आप बैठ।
Good evening and everybody. बड़े खुशी की बात है कि आज बड़ा इम्पोर्टेंट सब्जेक्ट था जिसके मैं हमारी सम्मानीय सभी स्पीकर्स को आपने बड़े ध्यानपूर्वक सुना, इसके लिए आपको बहुत बहुत धन्यवाद। हमारे जितने भी स्पीकर्स ने आपको स्पीच और आज के सब्जेक्ट के बारे में बताया, नो डाउट ये बहुत ही यादगार रहेगा, यादगार है और इस सब्जेक्ट के ऊपर आज का जो सब्जेक्ट और हमारे स्पीकर सभी स्पीकर डिटेल में आप सब लोगों को जो फैक्ट्स बताए हैं बहुत इम्पोर्टेंट हैं, याद रखने लायक हैं और ये आपके जीवन में जो हमारे न्यू लॉयर्स हैं उनको बहुत काम आने वाले हैं। तो मेरी तो सजेशन यही है कि जो भी हमारी लेसन सीरीज होती हैं और फर्दर होंगी, जितने भी यंग लॉयर्स हैं उनको हमारी सजेशन है कि आप नोट्स करते रहें, फर्दर कभी ना कभी आपके बहुत काम आएगी। ठीक उसी तरीके से जैसे किसी को फीवर होता है और एक टैबलेट काम कर जाती है, दैट टाइम से सेकेंडरी एक बहुत इंपॉर्टेंट है कि आप लोगों के अंदर जो हेजिटेशन होती है कि हम लोग 10 बारी कोर्ट रूम से बाहर गुजर जाते हैं, कोर्ट में जाना है लेकिन बाहर से निकल जाते हैं, हिम्मत नहीं होती है कि मैं कोर्ट में एंट्री कर जाऊं। दैट इज द बिग प्रॉब्लम। तो आप सब लोगों से मैं उम्मीद करता हूं कि इस हेजिटेशन को भी खत्म करें और इसी के साथ में हमारे स्पीकरों का दोबारा से बहुत बहुत धन्यवाद है। आप लोगों ने इनको सुना, इनके लिए प्लीज बिग क्लैपिंग के साथ इनका स्वागत करें और आज की मीटिंग मैं इंक्लूड करता हूँ एंड नेक्स्ट आप सब लोगों को सूचित कर रहा हूँ जो नेक्स्ट हमारी सीरीज है, लेसन सीरीज है, वो 10 है, वो क्रिमिनल लीव अपील इन दिल्ली हाई कोर्ट। सो प्लीज कम एंड ज्वाइन, दैट इज माई रिक्वेस्ट और humble request each and everybody. Big thanks, please. One request
and my speakers and audience, please take tea and thank you, thank you, thank you. ग्रुप फोटो के लिए सब लोग आ रहे हैं.